Let's move on to the fourth mistake people make about their revocable living trusts. And at the start, I discussed this. People think that their trust protects them. It does not protect you in any way. So if you're driving a car and your car is in the trust or the car is outside of the trust, doesn't matter, you get in an accident, you will be sued. Hopefully you have good liability insurance. That is the first defense. And I also recommend an umbrella policy. That's $1 million or $2 million excess policy. They're pretty inexpensive for the benefits they provide. But the mistake is assuming, hey, my house is in the trust, my investments are in this revocable living trust. Creditor can't touch them. Wrong. It's as if the trust didn't exist. Why? Because it's your money, you're in charge of it, you're the beneficiary. There is just no wall of defense between between a creditor and your assets. So you get no creditor or liability protections from the trust. So if somebody says to you, oh, you want a revocable living trust because it will protect you, please ask the question, in what way will it protect me? Remember, the number one reason to have a revocable living trust is so that you avoid probate. If you live in a different jurisdiction where the laws are far different than what they are here in Washington or in Idaho, perhaps you can get creditor protection. And I'm not addressing those other jurisdictions. I'm talking about the standard revocable living trust that you would get from online or from any estate planning firm who is providing your revocable living trust. You are not getting creditor protections. The one exception to that would be that, let's say that you're the trustee and you're losing capacity and now you're getting scammed. You're losing ability to manage your own assets. If you've named a successor trustee and if they're familiar with you and they see what's going on, that you're sending $10,000, to Nigeria or somewhere, then maybe that successor trustee will step in and take the reins away from you. But that's really the only time that there's going to be any help against financial exploitation is if a successor trustee steps in. And if you're the trustee, you might say, I'm fine, I don't want to step down. So that might not be the best situation either. Oh, sometimes people think that their revocable living trusts are going to protect them against long-term care or nursing home costs. Again, no. Your revocable living trust gives you zero protection from nursing home or other long-term care costs. And that's true even if, you're the surviving spouse and your spouse died and through the revocable living trust, there was an irrevocable trust created for you through your revocable living trust. In the state of Washington, it's crystal clear that if you want to protect the assets for your spouse when you're gone, the only way you can do that is through a will and not through a revocable living trust. So if your estate plan is based on a revocable living trust type platform, so to speak, you're going to get zero asset protection against long-term care costs. And that might be fine. You have ample assets to withstand a long-term care event, or you have long-term care insurance. For a lot of people, that works fine to have a revocable living trust because they don't care about long-term care costs. But if long-term care costs are something that you worry about or consider, or see an attorney who can help you get an estate plan in place that will protect you and your assets from long-term care costs. Your revocable living trust will not do that. Just a little bit of a mention about long-term care costs. At ELG Estate Planning, we do help people qualify for Medicaid, protect assets against long-term care costs. At the start, I talked about, there's irrevocable trusts, there's Medicaid trusts. Medicaid has a 5-year look back. Sometimes we create irrevocable trusts to get the assets so that they are protected after 5 years of creating that trust. Sometimes we do a Medicaid irrevocable trust that protects assets within the 5 years. Most commonly, what we do is we prepare a will that has an asset protection trust in it. And upon the death of the first spouse, all the assets of that first spouse are protected against long-term care costs, and the surviving spouse, those assets are there for their benefit, but they don't count in terms of any kind of Medicaid or long-term care eligibility. So if long-term care expenses are a concern, really reach out to an elder law attorney, not just an estate planning attorney, but an elder law attorney, because there's probably a lot of things that you can do to help protect your assets and make sure that your wishes and goals are going to be met. Yeah, so that was number 4. Thinking that your revocable living trust protects assets and liabilities. It doesn't.